everyone, and welcome to the update on Section 501R, Additional Federal Tax Requirements for Charitable Hospitals conference call. Today's conference is being recorded. At this time, I would like to turn the conference over to Ms. Ellie Kemeter. Please go ahead, ma'am.
Thank you, Lynette. Good morning, good afternoon, and welcome. I'm Ellie Kemeter with Foley and Lardner, and I'm pleased to welcome you to today's web conference. In this program, we address an update on Section 501R, Additional Federal Tax Requirements for Charitable Hospitals. I'd like to take a moment to introduce you to our program speakers today. First, we have Ken Appleby. Ken is a partner with Foley and Lardner in our Boston office, where he is a member of the firm's taxation, estates and trust, and private equity and venture capital practices. He has a broad tax practice which encompasses the areas of federal, state, and international taxation. Second, we have Mike Bailey. Mike is a partner with Foley and Lardner in our Chicago office, where he is chair of the firm's healthcare financing and restructuring practice, and a member of the firm's taxation, finance and financial institutions, and public finance practices, along with the healthcare and energy industry teams. His practice focuses on tax advantages financing, including tax-exempt financing and tax credit transactions. Lastly, we have Jason Cahoot. Jason is an associate with Foley and Lardner in our Milwaukee office, and he is a member of the firm's taxation, estates and trusts, and government and public policies practices, along with the healthcare industry team. Jason's work encompasses all areas of tax and corporate law and focuses on the areas of tax-exempt organizations, charitable giving, and political and lobbying law. Before I turn the presentation over to our speakers today, I'd like to go over a few housekeeping items. Today's program will last approximately 1 hour, followed by a short question and answer session. If you experience problems with on your telephone to reach an operator. Today's program has been set up in both a discussion and an interactive question and answer format. We encourage you to submit written questions during the program. Type your questions into the Q&A box at the right side of the presentation slides. We will respond to written questions at the end of the program, time permitting. To ensure you get the most out of today's presentation, we encourage all participants to maximize the PowerPoint to full screen usage. You can do so by clicking the full screen button located above the slides. The PowerPoint presentation will be available on our website at foley.com by early next week, or simply click the Download Files button in the Files pod along the right side of your screen to get a copy of today's slides. As a reminder, today's program is being recorded and will be available on Foley's website by early next week. Foley will apply for CLE credit after the web conference. If you did not supply your CLE information upon registration, please send an email to Ellie Kemeter at ekemmeter@foley.com. As a final note, those seeking Kansas, New York, and New Jersey CLE credit are required to complete the attorney affirmation form. A 4-digit code will And now I would like to turn the presentation over to our speakers.
Thanks, Ellie, and thanks to everyone for joining us today. This is Mike Bailey. Section 501R was, of course, enacted as part of the Affordable Care Act and sets forth additional federal tax requirements for nonprofit hospital organizations that are Section 501c3 organizations. A number of important developments have occurred in this past year, including the publication of 2 different proposed regulations. We thought this would be a good occasion to take stock of where we stand on 501R and to consider how best to respond to the developments to date and how to best prepare for developments that are likely to come in the near future. Now, this is in some ways an appropriate date to present this webinar because it's, of course, the back to work day for our friends in the federal government, including the IRS. And the IRS has stated on its business plan for this year that providing additional final guidance on 501R is a priority project. So we can all presume our friends at the IRS are hard at work on regulations that will have additional requirements for us to respond to. Our plan for this webinar is not only to provide a description of the recent developments, but also to consider practical steps for how to respond. We're going to start with a brief brief overview of the statute. And of course, 501R has four main requirements: a community health needs assessment requirement, a financial assistance policy requirements, limitations on charges, and billing and collection requirements. And we're going to describe all of these in somewhat more detail. This presentation is focusing on particularly on the requirements relating to the last three. That is the financial assistance requirements, the limitations on billings and charges, and the limitations on billing and collections, and also on the consequences of failure to comply. And recent guidance regarding the requirement to adopt an implementation strategy. And one thing we'd like to do is highlight both the similarities and differences between the community health needs assessment requirements and other requirements that have practical significance for how organizations respond to Section 501R. Of course, the community health needs assessment requirement is generally met once every 3 years with some additional annual reporting. On the other hand, the requirements relating to the financial assistance policies, the limitations on charges and billing and collections apply continuously to the operations of a hospital organization. And accordingly, the requirements other than the community health needs assessment may have more impact on day-to-day operations, and in many ways it may be more burdensome to respond to the regulations that the IRS is coming out with, because the IRS regulations will directly concern the procedures and policies organizations have for their operations. Of course, the community health needs assessment needs to be adopted each 3 years and take into account input. And Ken is going to describe the requirements in the code in somewhat more detail.
Sure. So thanks, Mike. This is Ken Appleby. Welcome, everybody. I'm glad you're able to join us today. As Mike pointed out, the statute contains a number of sort of key provisions that C3 organizations that operate a hospital facility are going to need to satisfy. In a sense, it's a codification, if you will, of the community benefits standard. Going forward here. What I'm going to do over the next couple slides very quickly, just drill down just a little bit more detail on what those primary requirements are, and then we're going to take a few minutes and go through some of these in a points out does have to be satisfied every 3 years. It's a rolling obligation. Of course, it's also time-consuming to produce, and as one of the things we'll talk about a little bit later is, how long can you procrastinate on this sort of thing? How do you actually implement policies and procedures that keep this and the implementation strategy that is derived from the China requirement moving ahead in order to meet the timelines? Because there are some significant penalties, which we'll also talk about, for failure to comply. The China requirement is not strictly an internal ball game. It does require input from a broad segment of the community, and we'll talk a little bit about how the regs, or the proposed regs in 2013 here, have attempted to define what a community is and who it is who has to speak to it, and what type of experts have to weigh in. In other words, how much public input, both expert and non-expert, are required in order to have a compliant community health needs assessment, methodologies. How do you disseminate? Once you've produced this thing, obviously it does require, not surprisingly, wide dissemination. How do you feel comfortable that you've actually satisfied those? And then what does the implementation strategy need to cover? For example, while this slide says the implementation strategy has to meet the community needs identified, it actually doesn't have to meet every one of them, but you do have to address every item every need that is identified, but don't have to necessarily implement them. But if you're not going to, you do have to obviously explain the reasons why it's appropriate for you not to address one or more particular needs. So Mike, if you would turn the next slide for me. The next requirement is that a financial assistance policy and a written emergency care policy, both are sort of lumped together, but they are two separate items, are required to be established for each hospital facility. I'll shortly talk to you a little bit about what when we say hospital facility, what that hospital organization, something that operates one or more hospital facilities, that one entity is going to have a separate compliance on all of these things with respect to each of the hospital facilities. So the definition of a facility obviously is quite important. With respect to the written financial assistance policy, there's a number of requirements for what this policy has to include. You do have to provide a financial assistance policy for certain members of the community, how that's defined, what the criteria is, how one qualifies, et cetera. We'll talk about shortly, and there is a requirement that there be a written emergency care policy. Now, note that is a little different than saying that emergency care services have to be provided by every hospital facility, because they don't. Typically, the Medicare EMTALA rules are followed for determining what, if any, emergency care is required for a particular licensed hospital facility, but you do have to have a written policy which does provide that emergency care will be provided without discrimination, and it's for more than just those who qualify for the financial assistance policy. On our next slide, we'll see the next requirement that charges for emergency and other medically necessary care that are provided to those who do qualify for financial assistance. Well, they're actually required, so I was going to say safe harbor. I'm not sure if that's quite the right terminology, but there are two schemes that a hospital facility can choose from in order to determine what the appropriate amounts that can be charged to those who qualify for financial assistance. And those, again, have to be, how you calculate it has to be laid out in some manner of detail in your financial assistance policy as well. There is the prohibition on the use of charge master or gross charge rates. The regulations in 2012 do indicate that you could, if you wish to, you can show on the bill the charge master rate, but you then have to show how it's discounted and the methodology for discounting that amount. And I know that had been sort of a controversial point before the regs came out. Then last but not least is the requirement that an organization not engage in extraordinary collection activities. We'll spend a few minutes on that shortly before the organization or the hospital facility has made reasonable attempts to determine who qualifies for financial assistance. In other words, while you're determining whether someone qualifies, you can't be undertaking certain, again, what they call sort of extraordinary collection actions, which are, obviously significant types of collection, leaning, foreclosing, other types of significant collection activities. So I'm going to turn it back over to Mike, who will sort of talk a little bit about the status of where we stand with all of these proposed regs out there, the two sets.
Okay, thanks very much, Ken. So where do we stand with respect to the IRS guidance? Well, we have two sets of proposed regulations. One set of regulations was published in June of 2012, which really concerned mostly the non-China requirements, the financial assistance policies, the limitations on charges, and the billing and collection requirements. And then this year in April, there were additional proposed regulations that concern mostly the China requirement but also very importantly address the consequences of noncompliance and some other points relevant to the non-China requirements. Now, the preamble to these regulations indicate that the final regulations are going to be published in one big package at the same time. So that will be quite a set of final regulations to digest when they come out. Just a few observations about what proposed regulations are. They're not currently effective, but they do address all of the rules in the code which are currently effective. And of course, 501R currently applies and needs to be met. Having written a number of tax regulations myself, I know that the IRS does take public comment seriously and often does significantly revise regulations between proposed and final regulations. I think my view is that the China requirements in the proposed regulations are possibly less susceptible to significant revision than the non-China requirements, that is the operational requirements, because, in part because the 2013 proposed regulations consider detailed comments to a prior notice. I'd also note that in response to the 2012 regulations, the IRS received about 200 public comments, which is quite a lot for them to digest. Now, these proposed regulations set forth very detailed and specific requirements, and arguably that's one of the problems with them. The rules in the proposed regulations are generally framed as minimum requirements, not safe harbors. And, we're going to observe that that actually creates a number of practical problems for organizations because, for instance, the IRS seems to generally want to have a one-size-fits-all approach for these requirements. And many of the public comments were to the effect that, well, many states have comparable provisions relating to requirements similar to 501R, and shouldn't 501R be written, these regulations be written in a manner that better accommodates and meshes with the various state law requirements. And for the most part, the IRS has not adopted that approach. They said, basically, we want to have some minimum federal requirements that may be in addition to state requirements. Now, it is a question about whether the service done so far, and I think that's one of the major policy decisions to be addressed by the IRS.
Mike,
yeah.
I got a quick question for you. Based on your experience, inside Treasury, so you have a sort of an insider's peek on how this process goes. I was a little curious the other day. I was looking at, we have the 2012 proposed regs that came out on the non-China requirements, and now we have the 2013 regs on the China and some of the compliance issues. The 2013 regs, touch on, there's a few modifications, if you will, of things covered by the 2012 regs. There were some modifications of those proposed regs. When we talk about, there's a lot of comments and there may be changes before the final regs. Can we read into it anything that they haven't made substantial changes in the 2013s with respect to the materials covered, substantive materials covered in 2012? Does that mean A, this is something totally different, and when they finalize it, there may be substantial changes? B, they've already thought about it, and they've basically said, yeah, well, thank you for your comments, but we're going to stick with what we've got. Do you have any sort of insight on that?
Yeah, I think we are speculating about this, Ken, but the subject matter of the 2013 regulations was generally different than the 2012 regulations.
Correct.
2012 was generally addressing the non-China requirements, 2013 the China requirements in more detail, and the consequences of failure to comply. So I don't think there's too much to be gleaned from what modest changes the IRS made to the 2012 regulations in 2013. I do, as I was saying, basically for the China requirements, the IRS has more or less had two different sets of proposed regulations because they had a notice and they had that they already have received comments for.
Right.
And so that's why I tend to think that it may be the 2012 regulations may be more susceptible to significant change.
Okay, interesting.
So,
So no, that's,
yeah, I do think that, just, for those who don't know the inside baseball of tax regulations, I mean, proposed regulations can't be applied by the IRS against taxpayers, including organizations. So they can't be used against any organization right now by the IRS, but as they stand now, they sort of bind the IRS because the IRS says generally that organizations can rely on them. So right now, these proposed regulations can effectively be viewed as established safe harbors, even though if they became final in their current form, they wouldn't be safe harbors. So that is sort of an interesting point in how organizations regard them, because you can adopt some of these provisions and be within a safe harbor, but you're not required to adopt them. Now, one thing we want to discuss in greater detail is whether to comply with certain specific rules in the proposed regulations right now, and that's going to require a great deal of judgment and sort of on a case-by-case basis. And I do think that the considerations for whether to comply with any specific provisions in the proposed regulations may not be for the China Jason, you were going to discuss some of the practical importance of the effective dates.
So this is Jason, and welcome to everybody who's joining us today. And as Mike said, I've been asked to talk about something very, very important, which is when does this actually become a rule that I have to follow instead of a proposal? And the 2013 regulations issued an effective date that said they would become effective upon the final date of publication, the date of publication of the final regulations. There is one exception. It's rather narrow, but it is important, and that is the third bullet point on the slide, and that is that for the China requirements, an organization is allowed to rely on the proposed regulations in completing its China health needs assessment for 6 months after the date of the publication date of the final regulations. And I think that's important because it allows a hospital to go down the road of doing its health need assessment under the proposed regulations, and then even if the final regulations are issued and become effective, the hospital organization can rely on the prior regulations or the proposed regulations in doing that, so you don't have to change your process in the middle of it. And then on the next slide, we sort of point out the issue with these proposed regulations and when they become effective. There it is. So the issue is that in the 2012 regulations, the idea was that these requirements, the non-China requirements, were going to come into effect in the first tax year of the hospital's first tax year after the regulations were finalized, which would allow some transition relief, right, between the date of the final publication and the organization's first tax year after that point. But now, I just told you that the new regulations will come into effect on the date of final publication, which means that there's no transition relief. Now, the preamble in the 2013 regulations does talk about contemplate some sort of transition relief. Unfortunately, it's very vague, and we have the quotation from the preamble in the second 12 proposed regulations, which was, as I said, the organization's taxable year, when the organization's taxable year began. Unfortunately, and Mike might have some additional insight into this, but we don't really have any good idea of what the Treasury Department will sort of decide is an estimated amount of time to come into compliance. So it's very difficult to sort of make decisions based on a transition rule that we don't really have any great idea as to what to tell you will be that transition rule.
Yeah, Jason, and my view is that it's virtually certain that there will be some type of transition rule that is a period of time for organizations to come into compliance. But whether it will really be a reasonable period of time to come into compliance is not clear. Because, one thing we'd like to discuss is, how to sort of prepare to respond to these final regulations knowing that there may not be a really reasonable period of time to respond to them. Maybe the IRS will say 6 months or something like that. But when you think about the process you may have to go through internally to assemble different functions, your legal, your financial, your billing and collection, your charitable assistance, all those different functions may need to be involved when you're revising these policies. And so there may not be as much time as is reasonable to really respond and revise these policies. And one point I think that's important to note is that if the IRS adopts final regulations and anything like these proposed regulations, almost all organizations are going to have to revise their policies in order to comply with them. So, Ken, you were going to talk a little bit about which hospitals and facilities are subject to the requirements, because the 2013 proposed regulations clarified that somewhat.
Yes, they did actually, and so this has been a topic that's had some interest. So here's an interesting, even though there's no safe harbor type rule, with the IRS has sort of defaulted on this point as to what is a hospital organization. Well, a hospital organization is a C3 entity, either existing or seeking. Sort of a facility has a physical connotation as opposed to a licensure connotation. The IRS has sort of opted, or Treasury has opted here, to go with a focus on licensing. And that's obviously state-specific, and states do vary on what requires licensing as a hospital facility, or as a hospital. And therefore, it does create some sort of strange issues that have been the source of a large number of comments. But so far, the IRS has sort of stuck to its original game plan. As a matter of fact, one of the very small conforming changes made in the 2013 regs over the 2012 is actually making things even more mandatory. So it's keyed off licensure. A hospital facility is something that the state licenses as a hospital. And when it comes to facilities, the 2012 reg said, basically all physical facilities that fall within that license, may be included within the definition. That has been changed to sort of shall be or are included within that definition. So any sense that there was any ambiguity or leeway has been eliminated. One topic that hasn't been discussed yet in either of the regs is what about if you have a single physical facility that has multiple licenses associated with it? That has not been addressed by the regulations. One thing that was touched on in 2012 that's now addressed more directly in 2013 is what do you do with pass-through entities, licensed hospital facilities that are owned by either a single-member LLC or in a partnership or joint venture type arrangement? Do you look through it? Is it the disregarded entity, meaning a single member LLC is really what we're talking about here? You ignore it, and the owner of that single member, the parent, is treated as owning that hospital facility, and hence is the hospital organization. That's a pretty easy one, and that comes, I don't think, as any particular surprise. The harder question was, what about multi-member, what about partnership or joint venture arrangements that involve a licensed facility? Are all of the members treated as hospital organizations? Is one of them treated as a hospital organization? How does that work? So the 2013 proposed regs say, start with the proposition, you look through, which would seem to imply that just about every partner, if you will, and I'll use the term partner even though we could be talking about an LLC and members, every partner could in theory be a hospital organization in that circumstance. But then there's some cutbacks. There's some exceptions that would allow certain partners to fall out of that rule. Exception number one: if one of the partners is exempt, because obviously it's only going to apply if it's an exempt org, right? Is exempt and does not have sufficient control such that the income, their allocable share of the income is UBIT, right, is treated as from an unrelated trade or business, that entity is not treated as a hospital organization. Again, a fair bit of logic actually on that one. If you're already treating it as UBIT because of the control requirement, it would be kind of odd to then be imposing the 501R requirements on the parent exempt organization. The second rule is what they call sort of a grandfather rule, and the real difference is it sort of cuts out the requirement that the income be treated as UBIT. And what the grandfather rule says, if on the date of PPACA's adoption, March 23rd, 2010, and at all times since, you were a partner in one of owning or operating, more importantly, a hospital facility, and they own less than 35% of by capital or profits of this joint venture vehicle, and so I got a lot of ands here. There is no control exercised or general control exercised by that party. Then that party sort of falls out of it, regardless of UBIT treatment or non-treatment. So that sort of clarification or safe harbor is sort of an important change, because there's been a lot of uncertainty in the sort of whole hospital joint ventures as to if there's multiple exempt orgs involved, who is going to be or if all were going to be treated as operating as hospital organizations effectively as a result of this. And governmental hospitals that have 501c3 status are subject to the requirements, and this is true as well.
Okay, now Jason is going to briefly describe some of the highlights of the 2013 regulations dealing with the China requirement.
Sure. So the first important thing to talk about, and the government received a number of comments about this and sort of made some rules, is China, there's a health needs assessment, but then there's also the adoption of a implementation strategy requirement. And I think a number of hospitals sort of were complaining or commenting that they did not have the opportunity or did not understand correctly the implementation strategy element of this. So the 2013 regulations contain a rather actually favorable transition rule for adopting an implementation strategy sort of after the fact. The general rule here is that for China and an implementation strategy have to be adopted in the same taxable year. Otherwise, the China is not an actual China for these purposes in passing the 501R requirements. So the rules here are pretty straightforward and generous. But if a China was conducting a taxable year beginning before March 23rd, 2012, then the hospital is allowed to adopt an implementation strategy 4.5 months in the first taxable year after March 23rd, 2013. So if a hospital who has a calendar year basis adopted a China in 2011 or 2012, it would currently be allowed to adopt an implementation strategy in the first 4.5 months in its first taxable year after March 23rd, 2013, which would allow it to adopt an implementation strategy on April 15th, 2014. And then after if the China was conducting a taxable year beginning after March 23rd, 2012, then the regulations provide for a 4.5 month extension, essentially. So for our 12, and it would have had to adopt that by the end of 2013, and under the transition rule, it's allowed to adopt the implementation strategy by April 15th, 2014. So moving on, we just wanted to touch base on some of what is required in a China. There's 5 elements. First, the hospital has to define the community the hospital facility serves. Now, the good thing here is that the regulations really kind of sort of throw it to facts and circumstances, and that's really good because hospitals are very, very different animals. You know, if you think of your very small community hospital away from an urban center in more of a rural area compared to, you know, some very specialized hospitals in city centers, it makes a lot of sense to be thinking of facts and circumstances here. The IRS does have some rules, the regulations have some rules about essentially not redlining populations that the hospital doesn't want to serve out of its community because they're unattractive populations. So you cannot exclude medically underserved, low-income, or minority populations unless you can establish that they're not really part of the hospital target population or affected by the hospital's principal functions. And you can also not exclude patient populations based on essentially lack of insurance or eligibility for financial aid, which we'll be talking about in just a second. The second part of your China requirement is to assess the community's health needs, right? You've defined your community. Now you have to decide what is the community, what are the health needs in the community. And there's some headers that should probably go in the report. The regulations ask for the hospital to identify significant health needs, prioritize the health needs, and then identify potential measures and resources that the hospital could bring to bear to solve or to remediate the important health needs. So the third point on our requirements of a China is more of a process point. It's a question of, you know, what is required to conclude who the community is and to assess the community health needs. And the idea here is that the regulations will force the hospital to take into account the broad interests of the community, including those with really should be addressed, must be addressed. One, someone from a state, local, regional public health department has to have input in this, in the China. And then secondly, individuals from a medically underserved, low-income, and minority populations have to be involved, or representative organizations who represent those populations have to be involved and give input into the process. The fourth requirement is that the organization has to adopt a written report. So it not only has to describe the community health needs assessment, the definition of its community, it also has to include some workups about, you know, what was the process for taking public input. And then the other requirement in the regulations, again, there's a lot of suggested language, but then so you get to the what must be in there, what you would want to make sure that you have in there to make sure that you're fulfilling the China requirement, is that you need to list the organizations that represented or were representing the medically underserved, low-income, and minority populations. And then lastly, when the report is all done, when the China is complete, you need to make it available to the public. You do that 2 ways. One, you post it on the website, on your website, and then secondly, you must make it available in paper copy at the hospital facility. So, and this is where I think things get a little bit dicey. This is sort of the add-on part, that in addition to the China, and maybe in conjunction with the China, there's this idea of an implementation strategy. And an implementation strategy is where, you know, the rubber meets the road. We actually take these sort of these community health needs, the significant health needs of the community that the hospital operates in, and the hospital says, yes, we're going to do something about it, and these are our plans. Or the hospital says, no, we do not intend to address that health need. And at that point, the hospital has to decide, you know, why are we not going to do this? And the regulations, I mean, this is certainly a legitimate thing for a hospital to say, we're not going to be able to address this health need. And the regulations give examples, you know, including lack of resources, not within sort of our priority. You know, we listed the health needs, and our priorities are these 3, and, you know, these other 3 maybe not as important. strategy must identify, and our second point there, must identify the programs and resources that the hospital plans to commit to address the health need, and then describe any planned collaboration with other facilities or organizations. In talking about this, kind of preparing for the presentation, Ken and I talked about timing. And I think in getting all of this done and getting it all done with your board of directors, timing is just essential. It seems to me that these are the sorts of plans that board of directors like to chew over for 2-3 meetings. And the requirement is that the China has to be completed, or the implementation strategy must be completed in the same taxable year as the China. And so you can imagine that if you're writing your China and you have to have town hall meetings to take input, and all of a sudden you're getting down to this time of year, right, it's October, and then now you're looking for the board of directors to sign off on a proposed implementation strategy, but the board of directors wants to sort of really wrangle with that. And you could see where a board of directors is very interested in doing that. You could see where all of a sudden, if you're a calendar year taxpayer and it's December, it's November and December, and your board of directors are all going to Florida, you can see where a hospital may run into really big issues in getting this all done.
Okay, thanks, Jason. Now we'd like to move on to a description of some of the non-China requirements which are addressed in the proposed regulations. And because time is running a little short, we wanted to focus on sort of a discussion of, what parts of the proposed regulations an organization might want to consider adopting now, or think about revising their policies in light of what the proposed regulations say. That is not harbor. So Ken, you were going to start with the content of the financial assistance policies.
Absolutely, and right. And this list is obviously a list of those that are not going to be subject to an extended, or not likely to be subject to an extended period. And obviously, as Mike pointed out up front, they are currently the rules. So obviously, as we said earlier, there are 2 written policies that are required under this. Not only the financial assistance policy, but sort of buried within it is also an emergency care policy, which is not the same thing because it applies to a broader group than the financial assistance policy does. Just to quickly, the 2012 proposed regs, sort of give you a whole laundry list of time periods for when people can apply and when you have to let them apply, et cetera. But the policy has to basically include eligibility criteria. It has to include the basis for calculating the amounts charged, and we'll talk about the limitation of charges in a minute. But that calculation and those details have to be sort of written in plain English, which is not actually simple to do. The regs are pretty tough on this one. They basically say, look, you got to live with what you ask for. If you say this is the method for applying and this is the information you have to provide, you can't come back later and say, well, we're a little uncertain, so we'd like you to supplement your application with some additional items that we never mentioned to you. If the policy doesn't state it, you can't ask for it, even if it makes good sense later on. So you have to be very clear up front with everything that is or may be requested in order to support the request for financial assistance. You have to lay out the actions that the hospital can take to collect unpaid amounts, and it also has to both do and lay out how it is going to publicize the policy. And I think Mike will be discussing shortly some of the issues and methodologies for wide dissemination, which applies almost across the board to all of these requirements. As I said before, we also have to have an emergency medical care policy. It typically ties to EMTALA. It also applies to anyone seeking emergency care, not just those that qualify for financial assistance. It has some requirements buried within it, including that payment or payment of other, older bills prior to receiving emergency services, and you cannot actually conduct debt collection activities within the emergency department or other parts of the hospital.
Okay, and one thing that's very striking about both the 2012 and 2013 regulations is they contain really extraordinary detail on the requirement to widely publicize policies. And basically they say that the financial assistance policy itself, the application form, a plain language summary, all have to be available on the website, and they all have to be available basically to patients that request them. The 2013 regulations contain a very specific and detailed regulation on what widely available on a website means, which basically it just has to be easily and widely accessible. They require plain language summaries and require materials in other languages based on a 10% standard for any language minority within the service area with limited proficiency in English. And just in terms of which provisions may survive to final regulations, my view is that some of this extraordinary detail about widely publicizing is likely to survive. In part, I say that because the service has basically repeated it in 2 sets of regulations, and in part, I guess one lesson I would take from these proposed regulations is that organizations may want to consider now, just as a safe harbor, thinking about some of this detail in terms of widely publicizing their policies. Now, of course, one practical problem that has arisen with many organizations is that, there's many different detailed requirements we're talking about. And in the case of a large number of organizations, actually the 501R requirements are met in a number of different policies, sometimes 4 or 5, 6 different policies. And the mindset of these proposed regulations is that you're supposed to actually make the policy accessible to the public. So some organizations have sort of attempted to reframe their policies in order to have one unified policy that addresses all of these requirements. That's a big job. But it is something that organizations may want to consider doing, or consider how they would do that if they had to, how they would combine requirements that may be scattered across a number of different policies, a billing policy, a charity policy, a policy on limitations on charges, and unify them into one. Now, maybe that's premature, but I think there's it might be an approach that some organizations should be considering.
Charges that can be assessed against those who do qualify for under the financial assistance policy, and that's to whom these rules apply. These do differ, and this goes back to the 2012 proposed regs. They do differ from the Blue Book standard, and actually, I do believe actually that the Schedule H on the Form 990 still has questions tied to the we'll call it the Blue Book standard, but that I think is going to be replaced by the two options that you'll have under the regulations when finalized. One is a look-back method, and the other is a prospective method. Both are keyed really on the Medicare fee for services, and the look-back method basically says what percentage of the gross charges, in the last 12 months, that's why it's look back. You're looking at your sort of historical. Did the Medicare fee-for-service patients pay, or you can choose Medicare fee-for-service and lump together with all private health insurers paying claims. So that's your choice, one or the other. You are allowed to break it down by different sort of different departments, different activities, so the percentages can differ as long as they're consistent. effective method. It is an irrevocable election. Now, whether that makes sense or not, I don't know. That query whether it really does. But for now, at least, until final regs change it, it is an irrevocable choice that you're going to make, and you're going to have to lay it out in your financial assistance plan as to which methodology you've chosen.
And Ken, I just observed that, you know, in the public comments, there was, of course, a lot of complaining about the specificity of this requirement because, for example, at the public hearing, there were representatives from Minnesota and California that said there are other methods that are used under comparable state law charity requirements, and why force hospitals to use one of these two very particular methods. The service indicated that they had considered those comments and not adopted them, but you know, I would think there's some significant possibility the service would be responsive to you know, the many comments they've received on complaining about the specificity of these two particular methods. But
yeah, the question is, where do they go with that, though? Because, you know, one way is you could turn these into safe harbors, but that doesn't really get at what they want. So I'm not so sure if if just using them as a safe harbor works. Do you say that the third method is, you know, something permissible under applicable state law in the state of licensure? It's you know, I don't know. Because it is inconsistent with the Blue Book, significantly inconsistent with it. So something happened in there, but I'm not sure what.
Okay, and well, let's move on to the limitations on billing and collections because, you know, basically 501R says that an organization can't take extraordinary collection actions until it's determined whether someone is eligible for a financial assistance policy, and the regulations have really extraordinary detail on this particular requirement, what reasonable efforts are to determine whether a patient is eligible. And you know, generally they define extraordinary collection actions by reference to legal or judicial process and also include selling debt and reported to crediting agencies. There is a notification period beginning on the first day care provided, ending 120 days after the first billing statement is provided. There's an additional 120-day period. There are requirements about what notifications need to be made in bills to patients, and you know, if there's a successful application during the second 120-day period, reversing any actions that have been taken. My view is that, you know, there's some significant likelihood that these particular time periods and the extraordinary detail in these proposed regulations may be loosened up, or there may be some more accommodation in final regulations. You know, I will say that one thing I think that has emboldened the IRS in writing very specific regulations is that the 501R itself contains at the end a regulatory authority for the IRS to write regulations. And they specifically say they have authority to write specific regulations on what reasonable efforts in terms of the extreme specificity and procedures are these limitations on billing and collections. And I think most organizations that you know, I see have not, you know, attempted to adopt these time periods. I will say that the thing that I think is highly likely to survive in final regulations is the definition of what an extraordinary collection action is. Because I myself have a hard time seeing the IRS back off on that one.
No, Mike, I just want to take a minute since I know we're getting closer to the end. So I just at this time want to announce the 4-digit code for those seeking Kansas, New York, and New Jersey CLE credit. And the code for that is UQU7. Again, this is the code for those seeking CLE credit in Kansas, New York, and New Jersey. And one more time, the code is U as in Union, Q as in Quincy, U as in union, and the number 7. Thank you.
Okay, Ken, you wanted to address how this relates to Schedule H in the Form 990.
Absolutely. So Schedule H, actually, the IRS just released the draft 2013 Schedule H. I don't believe the instructions have been issued. If they have, I haven't seen them yet. But the draft instruction for 2013, where they made a couple of changes, not a huge number of changes, but there's certainly been a few. The form, for the most part, with the exception of the limitation on charges section, which has still got the old Blue Book standard sort of referred to, with that exception, obviously the form over the last 2 years some of this is becoming mandatory now, depending upon the taxable years. But for the most part, a lot of this stuff is not substantive. It's not like there's one right answer, yes or no. It's more, a lot of these questions are basically what's in your, for example, financial assistance plan. It doesn't mean necessarily that these things have to be in there, but they want to know. On the other hand, one of the sort of the tasks, and this is worth spending a minute on, speaking very generally, one of the tasks of the 990 really is to flesh out, or suss out, organizations that may not be completely compliant with these rules. And historically, the Form 990 has been sort of a function of the accounting department in terms of filling it out, et cetera. Obviously now, especially with the expansion of the Form 990 in general, but particularly the sensitivity for hospitals with the Schedule H and all that's at stake, this is a much more collaborative endeavor to put together the Form 990, and I think a lot of care has to be taken to put together, shall we say, the right team, and that team will have to include folks much broader than just on the accounting function. All of these different areas that were touched on earlier, have to become involved, and even everything down to public relations has to be thought about, because these are being read not only by the IRS, they're being read by just about everyone else. State regulatory authorities, community activist groups, et cetera, are all paying very close attention. And as these forms become more detailed in asking these questions, the potential use for other purposes unintended by Schedule H and Form 990 and 501R also increases. And I think, wise organizations will put together, if they haven't already done so, task forces, to handle the preparation of the Form 990.
Okay, Ken. And, one of the very important parts, and I know we're running short on time, so we want to run through these final points quickly, in the 2013 proposed regulations are consequences for failure to meet the requirements. And one very helpful provision is that minor basically excuse foot faults may be very important and may be frequently relied on given the extreme detail of the requirements and the regulations. There's a somewhat more interesting provision that says if failure is not willful or egregious, it can be excused if the hospital facility promptly corrects and discloses. And they say future IRS guidance will provide rules for correction and disclosure. And it's not clear whether that would be disclosure that would be in addition to the 990 or within the 990. I think because they may want prompt disclosure, it possibly could be in addition to the 990. And this may actually be used with some frequency as well, and then it may be worth considering what the significance of that is. Among other things, it may be just embarrassing for the staff of an organization to have to make some of these extraordinary disclosures that they're out of compliance with 501R, and that the noncompliance is not just inadvertent. Well, the standards for what they mean by willful and egregious are not so clear. Particularly egregious isn't very clear. But they do seem to indicate that if there is a willful and egregious noncompliance, there would be um, consequences, and one of the main consequences would be that the revenues from that facility would become taxable. So, Jason, you were going to discuss that briefly.
Oh, right. The complexity here is that the proposed, as we say in this next slide, the point that we wanted to make with this slide is just that all of these regulations apply to hospital facilities. If your hospital corporation owns several hospital facilities, right, you could see an example in which, perhaps the hospital corporation, your 501c3, owns 5 different hospitals. 4 of the hospital facilities meet the requirements, and 1 doesn't. It's very easy to see a situation in which the organization could continue operating as a 501c3 organization, which creates a whole bunch of complexity.
Okay, and so we have a 3-tier test, basically, for application of 501R. Inadvertent, something less than willful and egregious, and willful and egregious. But in addition to that, there are provisions in these regulations for when noncompliance with 501R will result in revocation of 501c3 status, which is really a somewhat different question. And Ken, you were going to describe that.
Start off by saying, hey, you blow these requirements, you can very well be blowing your exempt status. But on the other hand, again, as sort of Mike was talking about before, it's going to take a fairly high standard to actually, which is good, to lead to revocation. It's a facts and circumstances test, so there's no easy safe harbor on this. But the factors are really actually very similar to the factors that apply under the intermediate sanctions and excess benefit transaction regs. You look at the relative size of the, what happened, the scope of the failure, the nature of the failure, the significance, and whether they've previously occurred. Do you have policies in place to catch these things? Do you not have policies in place? Did the policy fail? Was it inadvertent? All of those sort of factors. Oh, and last but certainly not least, right? Did we catch this, or did you catch this? Obviously that's gonna make a difference as well. But again, I think the takeaway from this, though, is that the bar is being set as it should be. Fairly high. A small inadvertent oopsie, in terms of compliance, or even something a bit more major, but a one-time failure, while it may result in some of these financial penalties, it shouldn't result in loss of exempt status.
So, Jason, how would it actually work if there were application of 501R to a hospital facility?
Right. That confusingly is the answer. No, the answer is that the hospital facility is going and depreciation that can be subtracted from the income of the hospital facility, and then the amount of the remainder, right? The income generated by that hospital facility that doesn't meet the 501R requirements is subject to tax. This is not, I think people kind of jump to the conclusion, oh, well, that's like unrelated business income tax. It's similar, but it is not the same. And in fact, the regulations state specifically that you can't aggregate 501R income tax with unrelated business income tax. And as we say there, that the regulations do provide this specific provision that ensures that if a hospital facility, before operating as a tax-exempt entity, had UBIT activities, those activities will not be taxed once by UBIT and then once by the 501R tax.
Yes, so I just wanted to make some observations about the favorable rules for tax-exempt bonds because owned by a 501c3 organization, and it's a bad use if the property is used in an unrelated trade or business. So the regulations say that failure to comply with 501R will not in itself affect the tax-exempt status of bonds, which is a very favorable answer. And I think many people were concerned that noncompliance with 501R would be an unrelated trade or business activity, or that the service could take that position. And indeed, my view is if they wanted to, they probably could have written the regulation that way, but they didn't. And so you could have a facility which was subject to tax and subject to non-compliant with 501R, but still be financed with tax-exempt bonds and be compliant under the bond rules, even though if the facility were used in an unrelated trade or business, the bonds would probably be bad. So that in itself is a very, very favorable rule. Now, it remains to be seen when these things are finalized what kind of opinions will be required or asked for relating to 501R, because technically you could have noncompliance with 501R and still have good tax-exempt bonds. To conclude, Ken, some final thoughts on responding to the proposed regulations?
Well, I think that, and again, I think we've been sort of talking about them sort of as we go here in terms of what the best practices are. But I will say that while things are, parts of them are likely to change, I think we kind of see what the beast looks like, at this point. And as Jason pointed out too, the timing is going to be tight, no matter what kind of transition rules are imposed. So beginning to pick off the low-hanging fruit, those things that can easily be done within sort of the existing framework of both what's required from a state standpoint and what's administratively feasible, organizationally at this point. I think starting to bring these pieces together, in a way to be sort of ready to go, I think makes a lot of sense.
Right, and just to wrap up, some strategies for preparing for the final regulations. First, we believe it's highly likely that final regulations will require most organizations to substantially revise their policies. So it's worthwhile assemble a working group of different functions within an organization that would be needed to revise the policies, for example, legal, billing, tax reporting, and so forth. And also consider taking steps to comply with certain requirements of the proposed regulations. One example would be those relating to the requirement to widely publicize the financial assistance policies. So with that, I'd like to thank you all again for joining us, and if we have any questions, we will be available to respond to them.
If you have additional questions or would like more information on their particular topics. And this wraps up our web conference today. Just as a reminder, today's program is being recorded and will be available on Foley's website in the next few days using the link on your screen. If you have questions regarding CLE for this program, please contact Ellie Kemeter at ekemmeter@foley.com. Please take a minute or two to give us feedback about the presentation today using the survey link on the screen. It is important to us to know your thoughts and helps us shape our